Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in for this post-decision episode of SCOTUScast. I'm your host, Nick Garfinkel. On June 17, 2021, the Supreme Court unanimously decided Fulton v. City of Philadelphia for petitioners. The issue before the court was whether the government violates the First Amendment by conditioning a religious agency's ability to participate in the foster care system on taking actions and making statements that directly contradict the agency's religious beliefs. Chief Justice Roberts authored the majority opinion of the court, which held that the refusal of Philadelphia to contract with CSS for the provision of foster care services unless they agreed to certify same-sex couples as foster parents violates the free exercise clause of the First Amendment. Joining us today to discuss this decision is Professor Mark Rienzi, President of the Becket Fund for Religious Liberty and Professor of Law at Catholic University.
Great. Happy to be here, and thank you all for tuning in. So we're here to talk about the Fulton versus City of Philadelphia case, which the Supreme Court decided on Thursday as a 9-0 win for the religious plaintiffs in that case. And I thought what I'd do is just give you a little bit of background on the issue and the case, and kind of how we got to the Supreme Court, and then a breakdown of the justices' opinions, and then a little bit of my takeaways from those opinions and what I think it means going forward. And then I'd be happy to take your questions. Let me start with background. So this is a case that concerned Catholic Social Services, which is an arm of the Archdiocese of Philadelphia, the Catholic Church in Philadelphia, which has been doing foster care in Philadelphia for much longer than the government has. Actually, the Catholic Church was doing the equivalent of foster and adoption care more than 2 centuries ago in Philadelphia, long before the government got involved. And it's a fight over whether the government can force religious foster care agencies to do home study certifications for same-sex couples. Won't surprise anybody to know that the Catholic Church has beliefs about sex and marriage. So if either an unmarried opposite-sex couple walks in the door, or if it ever happened, a same-sex couple walks in the door, the Catholic Social Services answer would be, look, we're probably not the best people to come into your home and do a study of your family life and then report our views about whether this is a good place to raise children. You'd really be better served by one of the other 28 or 29 agencies in the city. So the question in this case is really, can the government say that as a requirement of doing foster care, you have to be willing to certify all couples, or do the religious groups have an affirmative right under the free exercise clause to provide the care consistently with their religious beliefs? I want to frame that issue and then just pan back 10 or 15 years, because 10 or 15 years ago in the early 2000s, lots of Catholic in particular, but just religious foster care agencies faced similar pressure to what the Catholic Social Services faced in this case. But unlike Catholic Social Services, many of them just chose to shut down in the early 2000s. So in Boston and in Illinois and in DC and in several other places throughout the country, where the government put this kind of pressure on and said, no, you have to approve same-sex couples equally. The religious agencies said, well, I won't violate my religion, right? In other words, I'm not going to go ahead and say I really do think that's a great place to put children when I don't. But instead, I'll just close my doors, right? And so it was an issue that forced many religious foster agencies to close, and that I think 10 or 15 years ago was viewed as not winnable, to the point that people didn't even really bring the lawsuits. Fast forward to 2018, Catholic Social Services in Philadelphia had been able to continue in business, hadn't faced that pressure yet. But the city of Philadelphia found out through a newspaper article that Catholic Social Services had the policies it had, and if they were approached by a same-sex couple, would just refer them to one of the other agencies rather than doing the certification themselves. I always like to start out discussions of this case by pointing out something that makes me pretty heartened about the ability of people in America to live with people having different beliefs and different views, and report that there never actually was a gay couple in Philadelphia that went to the Catholic Church and knocked on the door and said, hey, can you come into my house and do this home study and give me your opinion of my family life and whether this is a good place for children? I suspect that the gay couples in Philadelphia who were interested in fostering an adoption knew they had a disagreement with the Catholic Church and said, nah, that's not the place I want to go. That's not who I want to come in and do my home study. I'll get somebody else to do it. Thanks. I don't need the Catholic Church's opinion of my family life. I always appreciate that when I think about it, that this is a case that started with no actual real conflict. The gay couples in Philadelphia weren't banging down the Catholic Church's door saying, I need this from you. But the city said, you have to do it. In other words, the city said, unless you promise ahead of time that if that ever happens, you will provide the home study, then we're going to stop you from doing foster care in the city. And they didn't just stop the agency, but they also stopped any family, any parents who were previously approved by the agency were cut off from receiving additional children. And the city did this at a time when there's a well-documented foster care crisis in the country in general, and in Philadelphia in particular. They'd put out urgent calls for hundreds more families that they needed to take care of foster kids in the system. They had lots of families through Catholic Social Services, and they just locked them all out because the city disagreed with the Catholic Church's beliefs about sex and marriage. So that all began in 2018. Catholic Social Services said to Philadelphia, look, we have our religious beliefs and we can't compromise those religious beliefs, but we can take care of an awful lot of children. And we've been doing it for a long time. And we think under the law, you really ought to give us an exception. The city said, no, we can't do that. And we're locking you out. So no more additional children will go to Catholic Social Services or any family previously approved by them. So Catholic Social Services filed suit in Philadelphia. We lost the case in the trial court and at the Third Circuit Court of Appeals. Both of those courts applied Employment Division versus Smith, which is a case from 1990 decided by Justice Scalia, in which essentially, the court said that at least for many religious exercise claims, as long as the government's law is neutral and generally applicable, then only rational basis scrutiny will apply. And so the two lower courts applied their understanding of Smith, which is a very religion-unfriendly understanding of Smith, but they applied their understanding of Smith to say, sorry, you get no special protection for your religious exercise here. Either get on board with the city's views of sex and marriage and what the lines ought to be, or get locked out entirely. We filed a cert petition in which we said that Philadelphia's approach was wrong and illegal. It's wrong and illegal under Smith. And if you disagree, it's wrong and illegal, and you should just change Smith, because Smith is obviously an incorrect interpretation of the free exercise clause. The case was argued actually the morning after the election. So, we were among the very few people who came into a boarded up Washington, D.C. that morning, came in through, into our office, into a boarded up city. It was during COVID, so we were arguing by telephone. My colleague, Lori Wyndham, did the argument and did a masterful job with it. And what we saw on Thursday was the fruits of that litigation, which is a 9-0 decision that Philadelphia had broken the law. Philadelphia had acted illegally over the past 3 years in stopping all of these families from taking in foster kids. It's an illegal action by Philadelphia that hurt a lot of real, actual human beings. A lot of real kids could have been in those homes, those loving homes, and weren't. Because Philadelphia was breaking the law. So now let me just walk through the different opinions and break down how they came out. So first, one, it's a 9-0 decision in that all the justices agreed on the outcome, which is Philadelphia violated the law and under the free exercise clause had to give an exemption. There were some differences as to the reasoning, but very importantly, not a single justice took up the pen to defend Philadelphia. In other words, no Kagan or Sotomayor or Breyer or anybody else dissent saying that Philadelphia's actions here were illegal or permissible. Nobody said that. Everybody agreed what they did was illegal. The only question was how big the win should be and what should happen with the doctrine. So the majority opinion is written by Chief Justice Roberts, and it is for Roberts, Barrett, Kavanaugh, Breyer, Kagan, and Sotomayor. So for those six, or a different way to put it is everybody except for Alito, Gorsuch, and Thomas was on that first majority opinion. And the majority opinion says essentially Philadelphia's actions violate the free exercise clause, and they do so quite clearly. And therefore, there's no need for us to go figure out whether we should reverse employment division versus Smith, because the actions are so flagrantly illegal that Philadelphia loses even under Smith, even without reversing Smith. So we don't need to go there today. And the way the court got there is it said, look, even in Smith, even before Smith, if the government has a system that involves government consideration of the particular reasons for your conduct, where they say, well, some reasons for doing that are okay, but not the religious reasons, that renders the law not generally applicable, right? And that Philadelphia had a system that allowed for individualized exemptions. And the court said, once you allow for that, you don't have a generally applicable law. And they also cited, well, they didn't cite it, but they repeated some language, versions of which they had used in the COVID cases from the past year, particularly the Agudath Israel Diocese of Brooklyn case, and then the Tandon case, in which they said if the government's going to have exemptions for secular conduct, they also have to have parallel exemptions for religious conduct. And if they don't, that is not a neutral and generally applicable law, and that gets you to strict scrutiny. The court also rejected the idea that foster care could be a public accommodation. And I'm sure it's not a surprise to folks on this call, but for several years now, one of the things that opponents of religious liberty have tried to do is try to make everything into a public accommodation so that they can say, well, baking a cake is a public accommodation, and, certifying foster families is a public accommodation, because they want to tap into a race analogy, say everything's a public accommodation. This is the equivalent of denying somebody a sandwich at a lunch counter or a ticket on the bus or the train. And therefore, the government can insist on non-discrimination norms in this context. Well, the unanimous Supreme Court rejected that idea. They said, no, this is obviously not a public accommodation. Certifying foster families and then matching foster families with children is inherently subjective, judgment-laden, detailed, individualized type of work. It is not like going to buy a cup of coffee or a ticket to the train. It is instead very subjective, very individualized, often very sensitive work getting into people's relationships and things like that. And it's just not a public accommodation. And so the court said it's not a public accommodation. And they said, therefore, for all these reasons, we get to strict scrutiny. Strict scrutiny, of course, requires the government to show a compelling government interest. In the Third Circuit had said, well, anytime the government invokes non-discrimination, that will count as a compelling government interest. The Supreme Court, unanimously rejected that. They said the Philadelphia does not have a compelling government interest here. They don't have a compelling government interest here that is sufficient to overcome the religious interest. The court also said that, and this is a personal favorite line of mine, that Catholic Social Services was not attempting to impose its religious beliefs on others. And anyone who's focused on the religious liberty debates of the past decade knows that the favored phrasing of the opponents of religious liberty is always to say, well, the Little Sisters of the Poor or Hobby Lobby or Catholic Social Services or whoever it is trying to impose their religious beliefs on others when they say, I can't do that thing. Justices agreed that is not imposing religious beliefs on anyone. That is simply Catholic Social Services having its religious beliefs about the work that it can do. The opinion also talked about how Catholic Social Services had been, had done very good social work. And I should also mention the name of the case is Fulton versus City of Philadelphia, because it's not only about the agency, it's really brought primarily by the foster moms, Sharon L. Fulton, Tony Sims Bush, and also Celia Paul. Celia Paul passed away during the case, so unfortunately she did not get to live to see her 9-0 win. She did get to live long enough to use her life, though, to foster more than 100 kids and to be deemed by the City of Philadelphia a foster parent of the year not long ago. So it, of course, would have been lovely if she had been able to keep doing that work to the end of her life, but she devoted an awful lot of her life to doing that good work. And ultimately, the Supreme Court's decision vindicates her work. So that was the majority opinion. And again, it said we're not going to go all the way and get Smith, because we can resolve this case short of that, so we don't need to. There was a concurrence by Justice Amy Coney Barrett that was joined in full by Justice Kavanaugh and in all but one paragraph by Justice Breyer. And the Barrett concurrence, the paragraph that Justice Breyer did not join was kind of the most full-throated questioning of Smith that said that she did not think Smith really comported very well with the actual text of the Constitution. But the gist of the concurrence was to focus on the question of, well, what would come next? And to say, Smith claimed at least, I think it largely failed, but Smith claimed at least to make the doctrine easier by coming up with a one-size-fits-all rule. Should we really pick just a different one-size-fits-all rule, or are we going to have to work out a lot of detailed questions if we try to replace Smith, and how do we do that? And ultimately, Justice Barrett said there's a lot of stuff you need to figure out. And since we don't need to go there because Philadelphia's actions are all clearly illegal, even if we don't reverse Smith, we shouldn't go there in this case. Justice Alito wrote a 77-page masterpiece of an opinion in which he explains why Smith is a bad decision and ought to be overruled. That opinion was joined by Justices Gorsuch and Thomas, and that opinion lays out the case in full detail against Employment Division versus Smith, explains why it's not a very good understanding of the original public meaning of the Free Exercise Clause, explains why it's out of step with a lot of other precedents, why there's no reliance interest to keep it, and why the court really should just overturn Smith now. Justice Alito argued that there was a possibility that Philadelphia would react to the majority's opinion and just make some slight changes and, make the same problems recur. We don't know if they'll do that or not. I really hope they're smart enough not to do that. We'll get to that in a couple of minutes. But his fear was if the court doesn't fix the doctrine, then these issues will recur. And get to more on that in a couple of minutes. Justice Gorsuch also wrote in a concurring opinion. He was also joined by Justices Alito and Justice Thomas, in which he took issue with a lot of the arguments that were made by the majority to avoid getting to Smith. And he said, look, I think in these different places the majority is reaching, and they really should have just gotten to Smith. So that's how the opinions lined up. Let me give you a few minutes of editorializing, and then I'd be happy to take your questions about it. One, it's a huge win. This is a religious liberty versus LGBT rights case, or at least that's the way it was framed up, right? Is that, it's this more of the zero-sum game of these two sides battling it out. And it was 9-0 in favor of the religious liberty claim. Not a single justice picked up a pen to say that Philadelphia was right. Not a single justice picked up a pen to defend Employment Division versus Smith. Every one of them said that Philadelphia had broken the law. Every one of them said that the Free Exercise Clause entitles Catholic social services to an exemption in this context. That's a very big deal. That's a very strong message to Philadelphia. If Philadelphia were tempted to try to come up with some weaselly way around the decision, there's 9 justices who just voted in our direction this time. They'd have to bet that we would lose 5 of them based on whatever change they make. That's not plausible. There's really no path for governments that want to keep religious groups out of foster care. I'll point out that the unanimity also does a couple things beyond the law, but to the extent we're thinking about the cases in the context of, ongoing public debates, if it had been a 5-4 or even a 6-3, you could have heard complaints that this was just about Trump judges, or it was just about Justice Barrett getting through at the last minute or something like that. 9-0, kind of gets rid of those claims, right? It's not about Trump judges. All 9 justices, to their credit, actually understand that the Free Exercise Clause requires an exemption in this context. It also, I think, made the decision, relatively useless as an argument for those who wish to pack the Supreme Court, right? If you were hoping for some good fodder for packing the Supreme Court, this decision surely isn't it, right? If this had been 5-4, you could maybe rally people and say, well, let's just add 2 or 3 more justices, right? A 9-0 decision is pretty clear indication that we're right on this one. And you'd have to really pack the court, right? You'd have to say, let me go get 10, none of whom will deviate from the company line that no justice is willing to pick up. So I think the unanimity also takes some wind out of the sails of that. Or just if you imagine the counterfactual of a narrow 5-4, it could have fed those things that didn't do it. I actually think the majority decision is a very strong decision. I don't think it leaves a lot of wiggle room for governments to get around this type of decision. The court said that if the government engages in particularized considerations of the reasons for your behavior, that triggers strict scrutiny. Just to take the foster care context as a starting point, but then to broaden it out. In foster care, it would be pretty impossible for a government to come up with a system that involves no discretion and involves no government looking at the reasons, right? Agencies are going to refer people sometimes to other agencies. That's happened everywhere in the foster care system for decades. And agencies sometimes are going to have to reject parents and say, you know what, this is actually not a great fit. And agencies are going to have to make detailed judgments about whether a particular kid is a good fit in a particular family. So there's kind of no way around the fact that a contract-based foster care system is laden with judgment calls and discretion. And once you get to judgment calls and discretion that the government is saying, well, that would be a good enough reason to refer somebody, but not someone else, but not a different reason, that wouldn't be good enough, you're going to trigger strict scrutiny. So I think the majority's decision actually, closes some doors and makes it much harder for Philadelphia or any other city that wanted to keep the religious people out of foster care. This kind of builds on the COVID cases. Again, I mentioned the Agudath Israel Diocese of Brooklyn pairing from Thanksgiving last year, and then the Tandon case about home worship. Those cases also made clear that if the government has secular exemptions, that's going to trigger strict scrutiny. And of course, the court here said that Philadelphia had already failed strict scrutiny, right? So if you look at those things and the way the court talked about foster care not being a public accommodation, what you get is a system that is inherently individualized and full of judgment, and therefore not the kind of situation that Philadelphia would be able to come up with some new special rule to go get Catholic social services. And let me also say, if after losing 9-0 at the Supreme Court on general applicability the way they did, Philadelphia tomorrow wanted to change its contract to get some new way to target Catholic social services, I'm pretty sure the justices would recognize that as intolerance of religion, which is a different way that you would get to strict scrutiny. So ultimately, the answer is Catholic social services gets to get back in the foster care game, and that's what the Constitution requires, and no justice thought otherwise. It's certainly true, as some people have commented, that the doctrine could have gone further. I agree very much with the attack on Employment Division versus Smith, set forth so well by Justice Alito and Gorsuch and Thomas in the Alito concurrence. But I think it's actually quite an advance that we're sitting here looking at a decision and looking at a court where at least 5 justices have now gone on record as suggesting that they don't think Smith is the right way to interpret the Free Exercise Clause. And another 2, Breyer and Chief Justice Roberts, may well ultimately agree with them. So I think we've actually moved the ball quite a bit down the field in terms of overruling Smith, even if they judged in this particular case that they didn't need to go all the way there. So I saw one of the questions was, will Smith be overruled? I sure think so. It's pretty powerful to have that many justices expressing the view that it should be overruled, and really just getting to the question of how do we figure out what replaces it? I don't know if that'll mean the justices will pick something, next week, at the last conference of the year, or they'll wait a little bit. But ultimately, I think the writing is on the wall that Smith is not long for this world. And if you combine, to go back a couple of years, if you combine Masterpiece Cake Shop and Tandon in the COVID cases and Fulton, what you ultimately get is quite a significant improvement in free exercise doctrine. There's a lot of ways to get to strict scrutiny. Lawyers looking at this who want to get their cases to strict scrutiny, a couple of years ago, Smith may have been a door slammed in the face of a lot of cases. Now, the answer is actually there's a lot of different paths that can get you to strict scrutiny, even without getting to overruling Smith. I still think Smith should be overruled. I think Smith will be overruled. But the doctrine is also a lot better and a lot stronger today than it was just a few months ago.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.